This is the subcommittee's third hearing in the last 3 months regarding the Voting Rights Act. I understand the focus of today's hearing will be on preliminary injunctions and bail-in coverage and election observers and notice requirements. I presume my colleagues on the other side of the aisle will focus on these provisions in the context of H.R. 4, the Voting Rights Advancement Act. Unfortunately, just like H.R. 1, the misleadingly named For the People Act, H.R. 4 seeks to federalize elections. This is about federal control, a federal takeover of an area that has always been within the jurisdiction of the states. That would be contrary to the Constitution's explicit mandate that it is the state legislatures that administer our elections. H.R. 4 intends to reinstate the preclearance requirement that was struck down by the Supreme Court in 2013 as unconstitutional. It was for a good reason, and it was well explained by the court. This bill seeks to lower the triggering mechanism, which subjects jurisdictions to pre-approval from the Department of Justice at the federal level before they can make changes to any of their election procedures. Additionally, the legislation puts in place so-called practice-based clearance requirements. These would require all state legislatures and political subdivisions to seek permission from the federal government before they can change certain laws and policies. This is regardless of whether the jurisdiction has a history of any kind of discrimination or is covered under the new formula. And this legislation is just another example of a politically motivated power grab to enable partisan federal bureaucrats to control our state election laws. Voting is a fundamental, constitutionally protected right in this country, and the 15th Amendment requires states to ensure voting is accessible and available to every American. States also need to administer elections that are free from fraud and administrative errors. The COVID-19 pandemic, as we all know, presented new challenges for the 2020 election, and it drastically altered how states administer their elections. Many of these changes were unconstitutionally implemented via executive or court order, completely bypassing state legislatures, as is required in the text of the Constitution itself. As a result of the 2020 election and the numerous errors that resulted, many state legislatures have duly enacted or proposed changes to their state election laws. They want to clean this up and make sure that we don't have the controversies that we had in the last cycle. These changes largely seek to enhance election integrity and increase the public's waning confidence in our election processes. It is outrageous to see the federal government fighting back against these common sense reforms, such as the latest lawsuit filed by the Department of Justice against Georgia over its election law. It appears to millions of Americans that we are weaponizing the DOJ and trampling upon essential states' rights and the will of the people enacted through their duly elected representatives. Let me be clear. Republicans want every legally cast ballot to count, but the only way to give legal votes the weight they deserve is to close the door to fraud and illegally cast ballots. I hope today we can have a productive conversation about voting rights and how we could best safeguard the ability of all eligible Americans to vote. I can tell you right now, the answer is not to go backwards and reinstate provisions of the Voting Rights Act that have already been deemed by the court to be unconstitutional. Our extraordinary republic has endured for nearly 2.5 centuries, based in large part on the understanding that our elections will be fair and free and secure. Our Constitution and our institutions will endure, but only if we support and defend them. That has never been more important than it is today, and I think we can all agree on that. I thank our witnesses for appearing today, and I look forward to your testimony. And Mr. Chairman, I yield back.
Thank you, sir. Our third witness is Maureen Riordan. Ms. Riordan is litigation counsel at the Public Interest Legal Foundation, which she joined in 2021. Previously, she spent 20 years as an attorney in the voting section of the Civil Rights Division of the U.S. Department of Justice, where she worked on hundreds of elections, voting, and redistricting matters. During the Trump administration, she served as senior counsel to the Assistant Attorney General for Civil Rights, where she was responsible for the voting section. Ms. Riordan received her JD from St. Mary's University School of Law and her PS in Criminal Justice from Seton Hall University. Ms. Riordan, you're recognized for 5 minutes.
Good morning, Mr. Chairman, ranking members, and members of the subcommittee. Thank you for your invitation to speak with you today. As indicated, I'm an attorney with the Public Interest Legal Foundation, a nonpartisan charity devoted to promoting election integrity and preserving the constitutional mandate that allows states to administer their own elections. I've been an attorney for approximately 35 years, 20 of which I served in the voting section. 20 years at DOJ, approximately 18 in the voting section. in addition to being senior counsel to the Associate AG for Civil Rights. From August of 2000 until the Supreme Court's decision in Shelby County versus Holder, my primary responsibility was to review changes submitted for preclearance under Section 5. I've also conducted election monitoring throughout the United States, both with and without federal observers. I began my appointment approximately 3 months prior to the 2000 election, and when the Florida recount occurred, I was shocked when I personally observed voting section staff discussing strategies, faxing, and receiving information from DNC operatives in Florida. I have also witnessed twisted racialism. When George Bush appointed Ralph Boyd, an African American, to head the Civil Rights Division, I often heard from career voting section attorneys that he's not really black and that no self-respecting black man would be a Republican. These statements and beliefs were many. I would urge every member here to read the DOJ Inspector General report on the voting section, and it provides instance after instance of bad behavior, often racially motivated among staff. It also includes abuse of an African-American paralegal deemed not black enough by voting staff. The voting section has a long record of abuse by its attorneys for improper collaboration in reviewing Section 5 submissions. It's been sanctioned by courts. Between 1993 and 2000, the voting section has been sanctioned over $2 million. For example, in Johnson versus Miller, the U.S. District Court sanctioned the voting section $594,000 for collusive misconduct by DOJ attorneys with the ACLU. A federal court pronounced that the communications between those two groups, the DOJ and ACLU, were disturbing, and that the dynamics were not those of an advocate reporting to a higher authority, but rather peers working together against the jurisdiction that made the submission. After a voting section lawyer professed that she could not remember details of the relationship, the court found her professed amnesia to be less than credible. Abuse of power in the Section 5 process is not confined to Johnson versus Miller, and my written testimony provides additional instances. Section 5 was a temporary provision for a reason that no longer exists. The Supreme Court made clear in Shelby County that only certain conditions would ever justify any formula for Section 5, including blatant discrimination on a pervasive and rampant scale. Triggers that are built around political, partisan goals will not withstand constitutional scrutiny. The permanent provisions of the Voting Rights Act, such as Section 2, still prohibit discrimination and provide ample tools to challenge election procedures. Up until this past Friday, when DOJ announced that it was suing the state of Georgia, the Department of Justice has only brought 5 Section 2 cases since Shelby County was decided. Where is the rampant discrimination? Section 3 also allows a judge to have a jurisdiction submit to the preclearance provisions if it finds that the jurisdiction intentionally discriminated against minority voters. And that is consistent with the Shelby mandate that federal oversight of state and local elections be closely matched to need. H.R. 4, however, would allow a jurisdiction to be subjected to the rigors of Section 3 for violations that are not premised on intentional discrimination. Also, the new evidentiary standard for obtaining a preliminary injunction proposed in H.R. 4 sets federal law on its head. The Supreme Court has held that plaintiffs seeking a preliminary injunction must establish that they are likely to cede on the merits, and also that the injunction should not be granted when it is against the public interest. The new standard in H.R. 4 not only disregards the public interest, but it actually prohibits the court from considering any interest of the state in an application for a preliminary injunction. I'd like to thank you for your time and your attention.
Mr. Roy is recognized for 5 minutes.
I thank the gentlelady. Mrs. Riordan, when the United States Supreme Court struck down Section 5, they did so, best of my understanding and recollection, in significant part because it was based on, at that time, 40-year-old data. and that it was based on information from 1968, 1972, and it was particularly dated. And in particular, that the record that was put into the record in 2006, when VRA was reauthorized at the time, was replete with examples where there were covered jurisdictions that had certain issues that were being raised, and then non-covered jurisdictions, but there was no real correlation, and that was part of the problem. Is that roughly correct from your recollection of the case?
Yes, it's definitely that there seemed to be no legitimate basis to have certain states covered at that particular time. And I think also the Supreme Court was very clear in what they said was it was always supposed to be a temporary provision, because they understood in the 1960s that there was, it was necessary to have Section 5, but that in the 2000s, it's no longer necessary.
Ms. Riordan, do you think the Department of Justice is particularly objective in the way that it would carry out preclearance? And just a simple answer on that one, and then I have to follow up.
I do not.
Are you familiar with the Department of Justice Inspector General report from 2013?
I am.
Are you aware that Chapter 4, Part 3 of the report, page 135, highlights that disclosures and other confidential information was leaked to reporters, likely by voting section employees?
Yes, that would happen on a regular basis.
And what kind of information was leaked? Can you provide examples, keeping in mind we're on the clock, but a few examples for the committee?
I think during the, I want to say the Georgia voting ID case, there were individuals who leaked information from the inner workings of the group that was responsible for reviewing that particular submission. I can think of that. I know that there were a couple of, actually one particular attorney that claimed that she was the basis for one of the books that was written about the DOJ. Those are just two examples.
Are you aware of the report highlighting that analysts lied under oath?
I am.
And do you have any background or examples of that?
I know that during the Inspector General report that there was a civil rights analyst that was specifically asked a question by the attorneys that were doing the investigation, and that she lied under oath.
The report provides examples of non-attorney voting section employees, posting comments to websites concerning voting section personnel or matters. One example describes an employee who started a, quote, cyber gang, unquote, that was engaged in, quote, cyberbullying, end quote. According to the report, he told the OIG that for his internet postings, he selected as his alias the name of the protagonist of a well-known novel because he represented the archetype angry black guy, end quote, page 129 of the report. Are these the same people that would be doing pre-clearances of election law changes under H.R. 4?
Yeah, there are some of those same people there.
Is that troubling to you?
Yes. I mean, one of the things that I found to be so shocking while working in the voting section was the fact that it was so political. I just think that a section that is termed voting, that is supposed to review voting changes in the Civil Rights Division, should be nonpartisan. It is the furthest thing from nonpartisan.
I apologize for being a little bit late. I had a conflict, but I suppose there's been some conversations here about H.R. 1 and S1 and about some of the issues involved with those pieces of legislation. Obviously, right now, having hit a wall in the Senate, do you believe that H.R. 4 is trying to be used as a backdoor to try to get the federal takeover elections carried out in the absence of being able to currently get that executed on the Democratic side of the aisle?
I do. I think that this particular bill is looking to reauthorize a provision of the Voting Rights Act that is no longer necessary because there is no rampant discrimination in voting. One of the things that I said earlier was the fact that during the time period that I was there, from 2000 until 2013, there were 222,000 submissions that were submitted by local jurisdictions. I would say that 98% of those submissions really concern moving a polling place within the same building. There is just not rampant voting discrimination between 2000 and 2013. There certainly isn't today.
When my colleagues on the other side of the aisle say that, quote, the Voting Rights Act has basically been turned over or overturned by the court, that's not true, is it, right? We're talking about Section 5. The Voting Rights Act remains firmly in place, protects the rights of American people to vote, but rather what we're doing is allowing states to continue to be able to figure out the laws and place voting booths where they need to be and so forth. Would you agree with that?
I would.
Thank you, ma'am. Yield back.